Steve-O with today's expert in their field.
Hey, good afternoon. I hope you didn't run into some rain like I did. We've got another Ask the Expert show today. Hey, you can call us in today. We have our employment attorney. I think that's one of the best shows, especially what's going on in the world right now. We have an employment attorney, Mark Berkowitz, and he handles employment law throughout South Florida. Probably could do it throughout all of Florida. Our phone number here is 888-565-1470 if you'd like to call in, you have a question. You can also watch our show today, and you can reach us on 95.3 FM or 1470 AM. This ought to be a really great show, especially with what's going on today. So let's welcome Mark Berkowitz. Hi, Mark.
Hi, thank you. It's nice to be here today.
Well, first of all, before we get to the meat, tell everybody about your firm.
Well, I practice labor and employment law with an office in Fort Lauderdale. I have a satellite office in Boca Raton, and I represent primarily plaintiffs in employment discrimination cases, but some small businesses as well in the field of labor and employment law.
Okay, so now you have a satellite office. Do they have to call and make an appointment with you on the satellite office? I take it you're not there every day.
Right. They can call the Fort Lauderdale office, and I'll make arrangements to meet them in Boca Raton.
So we're going to start off today, talking about Harvey Weinstein and sexual harassment. Would you say he's in a little trouble?
Yes, just a little bit. I was kind of surprised when all these stories are hitting the press, because I thought that this was an issue that had really been faded to the background now, because I think companies are more aware of it and are taking steps to protect themselves. But unfortunately, in many industries that are male-dominated and in mom-and-pop type industries, sexual harassment is still a pretty prevalent problem.
Well, I'm not trying to be cold or anything. What happens to him happens to him. But on a case like his, what can they come after him for?
Well, he has some criminal liability. As you know, there's a possibility of assault charges against him criminally. I mean, if he did harass employees of the Weinstein Company, he would have liability for sexual harassment civilly as well.
Is his company liable as well?
Yes, the company would be liable, yes.
Now, I understand he's in partners with his brother. Is the brother liable to? I mean, I'm sure they're incorporated, but how much does that protect them?
Well, in most states, the individual is not liable. The employer is liable for sexual harassment. But since he committed an assault and battery, both Harvey and his brother could potentially be liable civilly, individually, for civil assault and a battery as well.
Is this something, I know some women have accused him of rape, but is this something he could go to jail for?
Well, if criminal charges are filed and a jury finds him guilty, it's very possible that he is looking at some jail time.
Are there different types of sexual harassment?
Well, in the civil end of it, there are really two types. There's one type that's called hostile environment sexual harassment. And in that context, if the harassment in the workplace is so severe and pervasive that employees have difficulty even functioning, that creates a hostile environment. It could be jokes, it could be gestures, it could be stories, it could be innuendo. But if you reach that point that it's so severe and pervasive, then you have a hostile environment that is caused by the sexual harassment. The other type of sexual harassment is called legally quid pro quo, which means that the manager is expecting is giving a favor to the employee is giving a favor to the manager in return for job benefits or a promotion or something of that nature.
Well, so is there a retaliation come into with sexual harassment?
We often see a lot of retaliation cases if the employee makes a complaint to the Human Resources Division, and then the employer may decide to further take adverse actions against the employee. That's unlawful retaliation.
Well, let's take sexual harassment first. As the employer, what can an employer do to put a stop to this?
Well, an employer should have a policy and procedure whereby these types of issues can be properly addressed internally. And then the employer, under the law, has an obligation to take remedial steps to end the harassment. That's their responsibility. And if they do that, if they can accomplish that, then theoretically they wouldn't have any liability. The problem is that many human resource offices don't approach these problems in the right way and don't do what they're supposed to do to make sure that this is not a problem in the workplace. Oftentimes the manager may be very valuable to the company, and management may want to protect the manager because of his status within the company or the industry, and obviously that's going to create a big problem.
So this is a question that actually came to me this morning for our show today. So NFL football, the players are being told they should kneel. Is there something in their contract? I mean, to me, if you're working for someone and they pay you the kind of salaries they pay you, they should be able to say to you, when we play the national anthem, you're not allowed to kneel.
Well, it's interesting. There is some law under the National Labor Relations Board which says that employees can take concerted collective action in the workplace to express their interests. And I think that under that particular law, there are a lot of cases under that law, because it could be argued that the employees are taking concerted action, that I think that their conduct in kneeling very well may be protected activity.
So do you think, should a player maybe approach an employment attorney like yourself? Because then he's taking a chance of possibly losing his job. Well,
They're protected. They have a players association. They have a union that protects them. So
I guess what was upsetting is, I know the Dallas Cowboys wanted to put a decal on their helmet. It was for the 5 officers that were murdered in Dallas, and they weren't allowed to do that. So here's a team that is telling them what they can wear, what they can, what kind of brand that they can wear, but they're not allowed to tell them whether they can stand or kneel.
Well, again, it's interesting. That's kind of an open question. I think that would fall under the employee's ability to take concerted activity together in support of any rights that they may or may not have in the workplace. So I think it's protected. I think they do have protection that way.
Well, I wanted to get that in before I forgot it. We were talking about sexual harassment. Is there a such thing as sexual harassment when it comes to same sex?
Yes, there is. That's also considered to be unlawful activity. There was a case in the Supreme Court a number of years ago, the Oncali case, which held that same-sex sexual harassment is also a violation of Title VII of the Civil Rights Act.
So it's treated just like if it were the opposite sex?
Correct. Mm-hmm.
Okay. Now, I know this is going to be a big question. What about pregnancy? Have laws changed at all if someone should get pregnant while they're working, that they're allowed a certain amount of months off, guaranteed their job when they come back?
Well, there is a Pregnancy Discrimination Act that's pretty old now. It was first enacted in 1978, and it's part of Title VII, which says basically that the employer cannot take an adverse personnel action against an employee based upon pregnancy.
Meaning what?
Meaning they can't fire the employee if the reason for the firing was that employee's pregnant condition. which is sometimes difficult to show because the employer will always say, well, it wasn't because of pregnancy, it was because of performance or some other, collateral issue. But
does it work the same way if someone becomes ill?
Well, illnesses are protected by another federal law called the Family Medical Leave Act, but its application is somewhat more limited because there have to be 50 employees working for the company within a 75-mile radius. So it doesn't cover everyone. It covers mainly medium-sized employers and up.
Well, I think this, and we're going to be going to break in just a minute, but I think this should tell a company they need a handbook. And they can hire an attorney like yourself to assist them in putting this handbook together, because there is so much out there that a owner of a company needs to know about. Do you agree?
Yes, I think it's especially true in the small to medium-sized business that may not be aware of all these different issues and how to properly handle them.
If you think you or possibly have a problem at work, even if you're an employer or you're an employee, give everybody your phone number.
My phone number in Broward is 954-527-0570.
And you got a great website. Give them your website.
My website is markjberkowitz.com.
We're going to go to break right now. When we come back, I want to talk a little bit about unions, even though we don't have them here. We'll be right back.
Fort Lauderdale labor and employment law attorney Mark J. Berkowitz, P.A., specializes in labor and employment law legal issues, such as wrongful discharge, retaliation, sexual harassment, overtime compensation, the application of non-competition and employment agreements, as well as the denial of health care, disability, and/or pension benefits. If you have lost your job or believe you have been denied a promotion, you may have a legal remedy. If those personnel decisions were based upon discriminatory reasons, including race, gender, national origin, disability, age, or religious personnel decisions came about due to the filing of a complaint of discrimination. With the assistance of the law firm of Mark J. Berkowitz, P.A. in Fort Lauderdale, Florida, you can obtain the legal assistance you need in the wide and diverse subject area of labor and employment law. You will be professionally counseled on your rights as an employee in the workplace, and you will be provided with legal as well as practical options tailored to meet your needs in that specific situation. Call attorney Mark J. Berkowitz today for an appointment at 954-527-0570. That's 954-527-0570.
And we're back. We always, in the second half of the show, like to ask our guest here, why should people come to your firm?
Well, we always give personal attention to every problem, and we always return phone calls within 24 hours of receiving them. And my feeling is that practices of law, customer service is very important, and that's our main aim is good customer service.
It's funny you said that, because my Renee had to find an attorney, and she called and left a message, and 4 days later they called back. You know, when you think you need an attorney, 4 days is way too long. Give everybody your phone number again and your website.
My phone number in Broward is 954-527-0570, and the website is markjberkowitz.com.
So just explain to everybody, I don't know if everybody understands it. We have no unions here in Florida.
Well, we do have unions. We don't have what's called a union shop. You don't have to join a union in Florida, but there are collective bargaining organizations, unions, that do represent a number of employees. Most of the unions here in Florida, I would say, are more public sector, teachers, fire, other government employees.
Credit unions, I understand that some of the credit unions have unions, but you're not required to pay any dues.
Right, you're not required to pay, in contrast to states like New York, where there is a union shop where you have to pay. But down here, even if you're not a member and you don't pay, you are still protected by the provisions of the collective bargaining agreement. There's an interesting case that may come back before the Supreme Court. There's a challenge because up north, where there are union shops, you are required to pay a disposition fee or a fee for the union to represent you in different aspects of your job. So the challenge is that many employees don't want to pay this extra representation fee up north, and the thought is that the court is going to allow employees to back away from paying that fee in the union shop
So why would
environment.
anybody want to join a union?
Well,
Because they're still represented somehow.
well,
right?
if you're not a member of a union and you're covered by the collective bargaining agreement, often you'll probably have to get your own representation. You'll have to get your own attorney. If you're a member, the union will represent you in the grievance and arbitration process.
Tell me, I wanted to bring up when a company wants to hire you as an employee and they have a contract that they want you to sign. What are your thoughts on contracts? And I would say they should bring it to you first before they sign anything.
Right. Any kind of employment contract should be brought to a professional for review. Typically, employers down here may include a number of clauses in contracts, such as non-competition agreements or other types of restrictive covenants that may obligate the employee during the employee-employer relationship. So it's very important to have the contract renewed, fully analyzed by a professional. In addition, you want to check and see whether or not the employer is allowing you to get out from under the old style employee at will relationship. Unless the contract has a definiteness as to the period of time that it's going to last, you'll remain an employee at will, and the employer can still terminate you at any time with or without cause. So it's very important from the outset to really get a good understanding for the employee as to what is contained in that proposed employment contract.
Because they can actually own you after if they let you go, especially in the area of sales. Salesmen are many times told that if you are let go, you can't go calling anybody in this industry for 6 months or a year.
Right. That's pretty common, yes.
Tell me about, is it hard to put a claim in for discrimination? Is it hard to prove?
Well, discrimination cases are most often proven circumstantially. It's a rare case where there is direct evidence of discrimination. Direct statements of prejudice and bigotry are rather rare. The way that you can prove discrimination is that the aggrieved employee has to compare himself or herself to someone outside their protected class who was treated more favorably. In other words, if you are, for example, a female and it turns out that someone in your job classification, a male, is getting more opportunities at work, more training opportunities, other benefits at work, that raises an inference of gender discrimination. So that's really how most employment cases are proven in terms of circumstantial evidence.
Do you see many of those?
Yes, those types of cases are common. The cases where there is direct evidence of discrimination are obviously less common, but they do come up from time to time.
So we have the holidays coming up. We have Thanksgiving, we have Christmas, we have New Year's, and there's employers who want their employees to work on the holidays. Are they supposed to, it used to be time and a half. Is that still around?
Well, time and a half is governed by a particular statute. It's the Fair Labor Standards Act, and that only applies to overtime pay for employees who are qualified to get overtime.
You have to be qualified?
Well, the test as to whether or not someone is exempt from overtime requirements is the type of job function that they perform. For example, if they perform administrative functions or managerial, most likely they're not going to be able to get overtime compensation. It generally applies to non-managerial rank and file type employees.
Can an employer make you work on the holidays?
If it's for a religious reason, then I think the employer cannot. If it's for
Christmas.
Right.
So they cannot make you work Christmas. But going back to my original question, if you do work on Christmas or Thanksgiving or holiday, do they owe you more money if you're on an hourly rate, or can they just pay you the regular rate they pay by the hour?
Unless there's some kind of collective bargaining agreement that allows for a premium pay, they don't have to pay you more than what they usually would.
Wow. And talking about overtime, what's going on in the industry right now? Because I know people who work for Publix, and they get paid a salary, and some of them work 70, 75 hours a week. Where does overtime come in?
Well, the employees that you're referring to are most likely department managers who supervise more than 2 employees and who mainly perform supervisory functions in the workplace. Those types of employees typically will not get overtime because they perform a special supervisory function. And
that's what these are, too.
Right.
They're management people.
So they're management people. They're getting paid more than the typical hourly worker, and they're exempt from overtime requirements.
What is the law now with getting health insurance? Does a company have to provide health insurance if you're full-time?
They don't have to. The exception to that would be the Affordable Care Act, and there were a lot of new provisions that required employers of over 50 employees or more to provide health care. But that's the big exception.
Okay. Now, if I get hurt on the job, can my employer fire me?
Well, there is a law in Florida. It's an anti-retaliation statute, which says that if an employee files a claim for workers' compensation, then the employer is prohibited from firing that employee. There also are a lot of variations on that, though, because, for example, if the employee is hurt on the job and not capable of going back to work, unfortunately, the only remedy will be workers' comp benefits.
Right.
So it depends upon the severity of the injury.
Do they have to give them light work?
They don't have to create light work for the employee. If light work is available, then they're obliged to give the light duty work to the employee. But typically, if they don't have those types of positions, then they don't have to create them.
Getting to the LGBT now, employees, are they protected under Florida law?
There is no specific Florida statute, unfortunately, that protects LGBT employees.
No new rights, no federal new rights at all?
Well, there are some courts that are interpreting Title VII to cover LGBT rights. The 11th Circuit, our circuit, has said that Title VII does not cover LGBT employees. Another federal appeals court in New York has reached the opposite conclusion. So I think that because of those conflicts, the Supreme Court will probably look at that issue. We do have local ordinances, though, that protect LGBT rights. We have one in Dade County. We also have one in Broward County. but no state law per se.
Okay. And finally, there's the Family Medical Leave Act. Would you explain that to everyone?
Yes, there is a federal law that was enacted back in 1993, which allows for 12 weeks of unpaid leave for serious medical conditions for medium to large size employers who have 50 or more employees within a 75-mile radius of where the employee is working. And if the employee is absent for that period of time for a serious medical condition, he has to be reinstated to the same or similar job.
Well, I tell you what, I love the way you answer questions. I think that employment law lawyers now are more important than ever before. I mean, like I said, look what's been going on in Las Vegas. Give everybody your phone number again and website.
My phone number in Broward is 954-527-0570. And my website is markjberkowitz.com.
Now, our show gets out there. So if you're in Dade or if you're in Martin County, Mark can practice anywhere in actually the whole United States because it's federal. But if you're listening to the show and you're in another county, feel free to give Mark a call. One more time on the phone number, Mark.
The phone number is 954-527-0570.
Great. Thanks a lot for coming on today. And we have another show coming up right after this, another Ask the Experts show. We're going to be doing it on plastic surgery. We have one of the top plastic surgeons in South Florida coming in with us. And we're going to go to break. When we come back, we'll be with Dr. Rodriguez. We'll be right back.